Okay, I just received a notification.
Yes, ma'am. I believe we are live.
Yeah, it's showing live here.
Yeah, we are live.
Yeah.
Bhuvnesh, can you just share that link with Revati? I've just told her everything.
Yes, ma'am. I'll just do that right away.
Yeah. And even to those our WhatsApp groups and everything, so that everyone can be there. And we'll start sharp at 4. Till then, we can have the circulation of the links. कोई नहीं होगा ऑफिस में देखना जरा
I think it's 4, man.
Okay, so we can start. Yes. Ma'am. Yes, please go ahead. Okay. Bhuvnesh, I'm starting.
Yes, ma'am. Go ahead.
Okay. Good evening, everyone. Hope you all are doing well. This is Ms. Shivangi Sinha, Assistant Professor, New Law College, Bharati Vidyapeeth, deemed to be University, and Faculty Coordinator of Madhyasthta, the ADR Cell. I welcome you all on behalf of our college, that is Bharati Vidyapeeth New Law College. And Madhyasthta is actually a student-driven cell which was established by New Law College, Bharati Vidyapeeth, deemed to be University, Pune a year ago. And since its inception, the cell has tirelessly put in efforts to bring to its students unparalleled information pertaining to the field of ADR. Being a professor and ADR enthusiast, I was accustomed to the intricacies of subject and what all hurdles a students face. And hence we came up with Prudentia Amicus, a guide to career in ADR, which is a series of master classes wherein all the complexities pertaining to a particular subject of ADR would be unfolded and discussed in depth. The aim of Prudentia Amicus is to cover upon a wide spectrum of exciting and benefiting areas, topics in the field of ADR, and career prospects in the respective areas to enable the students to have a clearer picture of the same and guide them to make better future decisions in this field. Dear attendees, it is a great pleasure for me to introduce our speaker for today, Mr. Ankoosh Mehta, who is going to speak to us about the commercial arbitration and career prospects in the field. Ankoosh sir is an alumni of Government Law College, Mumbai, and serves as a partner at one of the India's most reputed firms, Cyril Amarchand Mangaldas, Mumbai. We take honor to share that sir is also a part of the advisory board of our cell, Madhyasthta. Sir holds great expertise in the field of commercial laws, arbitration, domestic as well as international. Considering Sir's extensive experience and knowledge in the field, I'm sure this session is going to be cornerstone for every students and every attendees in their career choice. We are beyond honored to have you with us for today's session, sir. I would also like to welcome Ms. Kriti Srivastava, who is an associate in Ankoosh Sir's team at the Mumbai office. She specializes in civil and commercial litigation and arbitration, as well as white-collar crime issues across various forums in the country. Kriti is not only the part of today's initiative, but is also going to address the attendees in our today's question and answer session. I welcome you, Kriti, on behalf of our college and our ADR cell. Now, I would like to welcome our Principal in Charge, Dr. Bhagyashree Deshpande ma'am, to tell you more about our university, college, and also our initiative. Ma'am, please.
Thank you so much, Shivangi ma'am. Good afternoon to all of you all. Bharati Vidyapeeth, deemed to be university, has a very distinguished stature and was established by Honorable Dr. Patangrao Kadam. Our beloved Chancellor, Honorable Dr. Shivaji Rao Kadam, has a strong inclination for research, and our Vice Chancellor and Secretary, Bharati Vidyapeeth, deemed to be university, who is also the Minister of Maharashtra State for Social Justice, is a perennial source of encouragement. Bharati Vidyapeeth, deemed to be university, is ranked 63rd by the NRF, and the New Law College has been consistently ranked among the top 10 law colleges of India. The New Law College is known for its innovative practices, and the creation of Madhyasthta Cell is one of it. The think tank of the New Law College thought it that we should give more and more knowledge and insights regarding arbitration, since it is one of the upcoming fields. And that is why we have created this platform, Madhyasthta, to give more information about arbitration, mediation, and conciliation. Now, today's program, that is the Prudentia Amicus, is a theme wherein we want to give the entire rainbow of the aspects related to arbitration, as Shivangi ma'am has stated. And today we have nonetheless our Ankoosh Mehta sir to start with. So without any further delay, I would like to ask Shivangi ma'am to proceed ahead with our sessions today.
Yes, definitely, ma'am. Over to you, sir. I would request you to kindly start with the session, sir.
Thank you, Bhagyashree ma'am. Thank you so much. To be here, and always an honor to be called and addressing, I can say, the future of the legal world. And it's been a great journey interacting with the core team of New Law College, and I can only say that this is only the beginning, and you guys have done extremely well, and I'm sure have an amazing future. Thank you for having me here, and I just want to I think it's the right topic which has been, which is here, and only for the reason that, arbitration has grown by leaps and bounds pretty much, I can say month on month, year on year, decade by decade. And why I say this is, I'll talk about arbitration as a career, arbitration as a practice, and how lawyers look at it, how the arbitrators look at it, how the supporting infrastructure comes into play, how you students, such amazing wonderful students having such wonderful legal minds, how you should be perceiving this. And at the end of it, if you're convinced, and why I will, I'm using these words very, very carefully, why you're convinced that you should take this up as your path. Whether arbitration is a good practice, I think the answer is most certainly yes. And I also come, and where I come from is, when I've had the benefit of working with my team members like Kriti and so many others who are always brimming with energy, brimming with confidence, and have always wanted to put their hand up when it comes to arbitration work, of course, but a lot of additional co-curricular work around arbitration. So whether it's participating in initiatives like this, whether it's writing articles, whether it's giving sessions. And I think this entire concept of arbitration is really, according to me, hit the right nerve center for the students. So I think I'll start by saying that arbitration would be a great choice as a career. But before we jump to, what an arbitration career is all about, and what should people be doing, I think it's very necessary to address the issue that what should be your formative years as a lawyer. How should you be focusing on your 5 years or 3 years of your law course? And at the end of the day, whether even whichever field of law you go, you have to be very passionate about the law, right? I mean, that goes without saying. Whatever you do, it has to make you obsessed, has to make you passionate. It needs to give you, in a good way, a sleepless night. If you're not getting an answer to a question, if you're not able to solve a problem, if there is some client's issue that you're continuously thinking about in the middle of the night, that's what keeps you awake. And that's what's very, very important, when how driven you are or how attracted you are towards a particular subject, and in this case, an arbitration subject. So I think to start with, I will say that is most definitely that you need to be a good lawyer, right? Good lawyer will mean having good ethics, of course, hardworking with the right attitude. I think, one along the way when one goes, and I'm not speaking for generally, but I'm just speaking, as a suggestion that, along the way, many of these things are forgotten. What we learn in our colleges, what we learn in our formative years, what our teachers tell us, we sort of forget along the way and, start only looking at it from the corporate world point of view. Yes, of course, you must. But at the end of the day, it's your learnings, it's your ethics, it's your culture, your code of operation that is really going to be able to sustain you. When you say that you practice in arbitration, later on what? You want to probably earn good money, you want to have a good name, and good name is going to come with goodwill, right? And these things become very, very important, as these fundamentals one should not forget, especially when, one is building one's journey. And the beauty of the profession of law is one's always learning, right? It's not like today I've said I've learned the Arbitration Act and it's over. Of course not. I think interacting with, you people, I'm going to get some more thoughts on arbitration. On the next session we have, we're going to have a more informed, updated, on this conversation. Talking about arbitration as a subject, I think the subject itself has adapted very well, right? Today you have, for pretty much any topic under the sun, any issue, any legal issue, any type of business, arbitration is a solution, right? Usually it's, if you talk about a real estate contract, if you talk about a power project contract, if you talk about a commercial contract, a shareholders contract, an M&A contract, or franchisor contract, sports contract, you will find arbitration there. So it pretty much has made a strong inroad into commercial business environment, right? I mean, today, businessmen, CEOs, CFOs, general counsels, everybody knows about arbitration. Everybody knows that there is an arbitration clause and something like this exists. So of course, There is a lot that arbitration is doing as a subject in terms of giving confidence to parties, in that, they will litigate upon something and the result will be out soon. In terms of giving a certainty of a process, because that's also very important that arbitration gives you. And of course, certainty of costs and time. But as we go along, I'll probably speak about it a little more. What is, and I'm trying to tell you the best in 20 or 25 minutes. It's very difficult to put together all the thoughts, because as we speak, we get a lot more. But I'm trying to give a balance of what it is from a from a practice point of view. And I've requested my colleague Kriti at some point of time to step in and say that how it works from a, she's been in the practice for a couple of years, so how it was of her journey of thinking, probably as a student, and moving into the practice world, that how probably things could be a little different. But there's a little bit of time for that. So in an arbitration, right, who are the stakeholders? Okay, of course, there is an arbitrator, there are lawyers on either sides, there are parties, sometimes there are counsels, there's a lot of infrastructure support if you have an institutional arbitration or something else. And your journey as an advisor in the arbitration, when do you think it begins? It begins from the first day the arbitration meeting happens? No, it precedes that long ago. And I would say it precedes from the time the agreement or the dispute in question that has been drafted at that time, when parties were all in a good mood and a good frame of mind. So at that point of time, what parties intended, why they drafted an arbitration clause, why they drafted the clause in that particular way, why they drafted the language of the agreement in that particular way. The person who was us, who's addressing those issues, really needs to wind the clock back and look at it from that time. That what, and try and replace yourself sort of in that position and say, okay, you are putting yourself 10 years ago or 5 years ago, when two parties decided to enter into agreement, and now thinking a year later or 2 years later how a judge is going to look at it. So it's that bridge that you form. It's that commercial, legal, probably technical thinking that you need to have, or you need to develop, or you need to at least have the aptitude for, while you're sort of focusing on a topic like arbitration, simply because the topics arbitration covers is very diverse. It could be something technical today that Kriti and I are advising on. It could be something on electricity that I'm advising on someone with my team. It could be something else on films that Kriti and I are advising on. It could be anything, right? And so that's why you need to have an adaptability of a commercial sense. And that's very important when it comes to any commercial dispute. And commercial dispute means arbitration. You'll pretty much be arbitrating on some commercial dispute or the other. So that's again a very, very important point of view. As far as the role of lawyers is concerned, now you will, in any arbitration, as I said, there are parties from both sides. There's a claimant, there's a respondent. Now, the claimant's team will essentially consist of a senior member, probably in a firm like ours, partner like me and Kriti and some other junior. And we all have a defined role to play, right? Maybe I am doing a strategic thinking. Maybe somebody else lower, under me, with me, is doing a little bit of the drafting work and, the client coordination work, the research work. Somebody else below that is doing a lot of, hygiene work, a lot of, case law research, a lot of, just general admin work. And all this entire sort of, balance or combination needs to come together for any effective deliverable of any effective product. It could be a letter, it could be an opinion, it could be a draft, it could be a hearing, it could be arguments, it could be anything. So it's essential that, when there are big matters, etc., teamwork is extremely important. Understanding your partner, understanding your colleagues, understanding these things become very important. And we've seen it in matters. We've seen it in matters that today, we, before every important hearing, right, in an arbitration, etc., in a court hearing, one will always have a trial round, a pre-prep round. So, probably me and team members are sitting, okay, this is how the arbitration going to go on for the full day. The arbitrators are 3, right? They will ask for their, assistance on papers. Somebody from the team needs to be familiar with that. Somebody from the team needs to be familiar. If I am the counsel arguing the matter, somebody from the team must be familiar and keeping pace with me as to what I am arguing. Somebody will be assisting that person who's assisting me for the papers that he or she wants. So there's a lot of coordination, a lot of time involved, and that all these small steps finally go and land up into what becomes a successful arbitration, right? Of course, as I said, it's great because there is a lot of certainty. It's great because there is a lot of glamour, because you're probably interacting with best legal minds, retired Supreme Court judges, High Court judges. You're meeting them at a very proximate distance. In another case, when they were sitting up there, you would never ever be able to interact them in a slightly more informal setting. In a lunch break, you will talk to them, you can go and introduce yourself to them. So these things matter a lot, right? And these things, and more or less, one other point that I'm trying to get at is, knowing the strengths of how you pick a team. Okay, so from the client side, if you think there's a technical arbitration, um, you probably ask the client, okay, I need your engineer, I need so and so, I need so and so to brief me because it's too technical. The legal team doesn't know it. So that's one part of it. From the in-house league, from your legal team, who's the best person to work on the job. The third thing, selection of an arbitrator, right? You should always be very clear about whose strengths are what, and by the time you get more and more experienced, you will know. So I'll give you an example here, right? Many of you would know that today an arbitrator gets appointed. I mean, one of the criteria would be that it could be a retired High Court judge or Supreme Court judge. Fair enough, it's a great credential and one must do it. But how many people do know that the journey of that particular judge before he or she became an arbitrator? Probably he or she never had a commercial matter or rarely dealt with a commercial matter. He probably done writ matters, criminal matters, constitutional matters, industry matters, labor matters. Rarely did an arbitration. Why would you select such a person? So a lot of study, a lot of thinking also goes behind the fact about this, who should be the arbitrator appointed, knowing in the strengths and weaknesses of your of the other side, of their case, of the procedure available at hand, and goes back to another very important question. In an arbitration is the closest you'll come to a trial. Trials in India, in Bombay and other places take years, 2 years, 4 years, 6 years, 8 years, 10 years, and it's never ending. But in arbitration, you'll see the trial start to end max to max 18 months, 2 years. But trial law, that consists of Code of Civil Procedure, Indian Evidence Act, and Indian Contract Act in some cases, is extremely, extremely necessary to by heart. So just remember that, those people, I'm not saying this, you should not be focusing on, but those people who are very keen on, focusing and developing a practice on arbitration, please try and ensure that your fundamentals of Evidence Act, Code of Civil Procedure are made much stronger. Of course, you're going to tell me that practical experience prevails over academic experience for sure. But at the same time, it's necessary to be very clear on, your Evidence Act principles. Like, what is evidence, what is secondary evidence, what kind of documents can be produced in evidence, what is evidence about, what is cross-examination about, what are certain rules of cross-examination, what is re-examination, evidentiary value of documents, when can experts be appointed. There are so many things. Today your entire business virtually, and especially in today's times, is happening all over email, right? What is the evidentiary value of an email? Where do you get that under the Evidence Act? There are so many procedural things that become very important. In fact, I would tell you, half the time, many of the judges are not aware of it, right? Because as I said, they've not come across from that stream. They don't know. Of course, they may be very happy to arbitrate and look at a dispute afresh, but your client doesn't want to risk his case for somebody else's learning. That brings me to the next question. Next point, that I was talking about anything to do with arbitration or any matter. It could be tomorrow you may say, okay, I'm also keen in real estate law, tax law, commercial law, intellectual property law. Great, go ahead and do as you please. But at the same time, it again comes back to your basic principles, what they call in law school, your first principles, that cannot be compromised. That is extremely crucial to whichever branch of law that you practice in. Okay, One, of course, thing is that, if you're looking at a commercial arbitration practice to develop, great idea, as I said, and, it's perfectly fine to sort of, move towards a developing of that strong base. But at the same time, you probably will end up missing out on other branches of law, like such as criminal law, which, you cannot probably arbitrate upon, of course. And certain other branches of law, which, don't have an, arbitration doesn't permit those type of disputes to be arbitrated. For example, probate law, matrimonial law, as the case may be. So that's another sort of, thing that you may want to remember if you at all want to go ahead with the practice of arbitration. As I said, there's enough room, and, you should not feel that, if I'm going with the practice of arbitration, miss ho jayega. No problem. Make your name in that. There's absolutely no difficulty at all. The other thing arbitration allows you to do is argue many of the interim applications, yourself, which is very different in a court of law. Of course, in a court, many times the time limit is less. So, the window to close your case is less. At that time, face value and many other things matter. In an arbitration, the processes are well stretched, flexible, well defined. So, you can, if I were the case, I'd probably send somebody like Kriti for a, smaller application or something like that, where, she will develop her confidence on, building an advocacy skill, or, whatever else it is. And it's the right platform to, build on your, finer touches, your sort of, wish list many times to, to complete certain, wishes that you have in terms of advocacy, in terms of drafting, in terms of, so many other small things that sort of come along the way. So again, that becomes a very, very important, this thing. The learning is very good. Learning is probably very fast, because when you're talking about, arbitrations, they have to be completed within 18 months, right? So you're always on a time crunch. That's one arbitration. Imagine you have 3 arbitrations going on. You don't have the time to breathe. So that is on arbitration as a practice, etc. Of course, when you have an interim award against you, have a final award against you, you can go back to the court to appeal, to challenge, as the case may be. But over time, that we've got to know that many lawyers, many advocates, many counsels who sort of are very good in their subject, they prefer that they will be more selective with arbitrations and try and focus more on court work, because that's a perception, that's a view that many counsels have who have spoken to. And probably they feel that it's the law is better built, and their journey or their career, etc., is better built in the courts, in the court doors, in the courtrooms. But again, it's a choice that somebody wants to make in terms of if you love arbitration subject, go ahead. If somebody wants to say that, no, I want to practice constitutional law, I want to practice this law, that law, then you'd rather be more of a generalist, practicing different areas of law and not focusing on arbitration as such. Although, as I said, no harm in calling yourself an arbitration expert. It's perfectly fine. Yes, of course, there is a lot of certainty in arbitration, as I said. So, you know the timelines from the day you sign up for it. So very often, if you were to focus on a career of arbitration, the experience that you'll end up getting is definitive, is concrete, and, can be well documented. You can probably boast of saying that I've completed a trial in 18 months, but on the same thing, if a court matter was to be filed around that time, you may not have the satisfaction of saying that this case has got over, because it's not. More likely or not, it's going to be delayed, because whatever said and done, we do face a backlog. And because of that, and because of the current times of, COVID, things have, sort of got delayed. I was in a matter this morning, where we were appearing before a court. And the court asked us that, fine, what's the urgency? And, that we are in these times. And in another case, probably the court would have said that, okay, fix it for hearing in 2 weeks. Court's given a longish date. So with these times, with, with the challenges that we are facing today in working from a virtual reality, I'm not saying it's going to be a permanent reality. At some point of time, probably there'll be a little bit of a hybrid version of, working from home with working from office, with some sort of a flexible rule there. But if you want to, sort of look at it from a perspective that whether an arbitration choice career is the great decision, I think the answer is yes. So you're not going to be undermining yourself or compromising yourself if you're going to be saying that, okay, oh, but did I miss out on something? That fear of missing out, or as many from your generation would be calling it FOMO, is absolutely fine. I mean, you don't need to worry about that. So there is a lot of satisfaction, as I've said, and a lot of individual and learning development that can happen. And the learning is very close because you're observing people from close quarters. You're observing a senior counsel, observing a judge, probably observing sometimes experts, right? I mean, a role of expert in an arbitration cannot be forgotten, right? Today, when we have a damages claim or we have any other claims that may come up, lawyers are unable to put a number to that damage. So you have very seasoned experts who come in, and who probably, try and sort of, develop those numbers, and, interacting with those technical minds can only help the learning. So from that perspective, again, I think it's a great choice to, sort of build on as a career. I think I'll probably make one more point. I think we're probably running close to the time allotted. Is that today in a virtual reality where you're definitely going to have a limit on sort of screen space and drafting, etc. And arbitration is best because as such it remains unaffected. So you can there are no such formal rules, etc. So virtually you can have an arbitration absolutely anywhere in the world sitting from your room. So that's one big advantage. And second advantage is on drafting, right? Today there is a little more flexibility given by arbitrators, to sort of prepare your pleadings, etc. There's no doubt about it that always pleadings were meant to be concise, but today judges are insisting on keeping pleadings concise and necessary, because there's only that much that on a computer screen or an iPad or whatever other device they have that can read. So I'll probably just sum up briefly to say that it's if you have a passion, pursue it, but also evaluate your options before going down that route. Not that you can't make a switch in between, but it's always good to be clear and spending more time thinking about what you want to do and why you want to do, and as much as possible trying to get a feel of things better firsthand, and then sort of making a choice. But I'll just probably end by saying that it's a great choice. Thank you.
Thank you so much, sir. It was really a brainstorming session, and I'm sure that a lot of students and our other attendees might have been benefited from this knowledge sharing session, sir. Now, I would request Sanya, the student of New Law College, Bharati Vidyapeeth, deemed to be university, and also the member of our cell, Madhyasthta, the ADR cell, to start with the question answer round. Sanya, over to you.
Thank you, ma'am. All right. First of all, thank you so much, sir, for such a wonderful session. It was extremely informative and provided a great perspective. Now we'll start with the Q&A session. So the first question that we have received is from Ansh Jaiswal. Prior to listening to your in-depth views on commercial arbitration, could you tell us why do parties prefer arbitration over litigation? Is it truly a more effective dispute resolution?
Thanks, Sanya, and thanks for the question again. So as I've said, that today it's more of a mindset, more of a business you are in, that you're probably going to decide why arbitration over litigation. As I said, the advantages are very clear for people to see. There is definite cost effectiveness, time effectiveness. There is a certainty in the process, and your result. 18 months, 20 months, your result. In fact, having the benefit of interacted with companies and clients from overseas, right? One of their biggest challenges has been the legal system in India, because they say that if we get stuck and we want to bail out, the courts in India are going to take too long. And that's when, arbitration, etc., have been a big confidence builder for them to, sort of take these, steps in India. And you can see that the kind of infrastructure that, foreign investment is generating, and, and the dispute resolution process is so robust, it really helps in, sort of, as I said, in the overall discipline as far as concerned. I won't say I probably just conclude on this point by saying that it's not a one-stop solution. There are at times you probably feel that this matter is better litigated in court, but more or less arbitration does have many keys to most of the locks.
All right, so thank you. So the next question we have is, do you think there are any lacunae in the Indian arbitration law that is hindering smooth functioning of commercial arbitration practices in India? The question is asked by Himanshu Pandey.
Thanks. I would not think there is any lacuna as such. I mean, before I maybe a bare minimum to my understanding and practice, but I think the point here is the Arbitration Act has been evolving, as I was saying in the beginning of the session, at a very, very informed and a very, very speedy pace. So it's trying to grapple with the issues that we face. It's trying to grapple with, the different concerns and etc. that has been coming up. Of course, it does have a long way to go with the more established international players. But, on a lacuna, I think on an overall basis, probably I would have said this a few years ago. But currently, with the timelines, with, Section 9 interim reliefs available in international commercial arbitration issues as a default, process of appointment of arbitrators, etc., the entire fee schedule, the entire disclosures that the arbitrators have to give, I think we're on good ground.
Okay, so thank you. Next question is from Shelja. What are the present factors that will shape the future of commercial arbitration in India, keeping in mind the current scenario?
You guys. Yeah. You all are the present. You all are the factors that are going to change this thing. But anyway, I think there's a lot, as I said, that is going to develop. The entire virtual reality is one thing that's really helping. I think the second thing, as I said, is because of this, it has had a consequent effect on courts, where there has been delays, etc. And, they're not able to cope with so many things. And at the end of the day, I think, the client and the lawyer and everyone's going to think that, where is justice best served and delivered? And actually, as they say, justice seems to be done. And that actually happens. So I think it's got a very bright future. More and more, I think that the courts are interfering less and less in arbitration matters and trying to give it the sanctity it deserves and the process it deserves, because that's why it's called as an alternate dispute resolution and not a subordinate dispute resolution as such. So, keeping all these factors in mind, I think, it's probably, I think it can just only go ahead.
All right, sir. So the next question we have is from Bhumi Agarwal. The question is, as per 2019 amendment, which specifically provides qualifications of an arbitrator, do you think this is a step taken in the right direction or acts as a barrier for India to emerge as the international seat of arbitration?
Thanks, Anya. I think Kriti had done a lot of work on this. So Kriti, I think you may want to take this one.
Sure. Thank you, Ankoosh. Primarily, at the outset, I don't think that's the only determinative factor to understand whether India is actually going to emerge as an international seat. But the amendment that came up in 2019, it does, in a way, primarily we'll have to see how it pans out when the practice really starts, when people start actually implement the sections and actually start applying to such arbitrators. But the amendment does actually have an indicative that a foreign scholar or a foreign registered lawyer may not be able to arbitrate an international arbitration, which I understand where your question is coming from, that if you have less and less foreigners on an international arbitration panel, or the different nationalities aren't really available on the panel, whether that sort of actually will impact choice of a foreign investor in India. But as Ankoosh was saying earlier, like in any arbitration that actually happens in India, our first choice is actually retired judges. Of course, choosing the right judge is important, but primarily because they have vast experience, and if they've done commercial matters prior, then they have vast knowledge to be able to deal with such an arbitration. So I wouldn't say that just because you have qualification of an arbitrator today, it will hinder us reaching to a point where we are one of the preferred choices of countries.
Thank you, ma'am. You summed it up really very nicely. So moving on to the next question, which is from Kriti. Since arbitration is flexible as compared to litigation, slight deviation from law may be permissible. Could you give an example of such deviation in terms of substantive law?
So I think I'll talk about a few examples. One being that, it's more flexible when you probably want to take an adjournment. I think this is the basic thing that comes in all matters. Sometimes in an arbitration, the judge, in a court, the judge may, not be comfortable or be kind enough to grant you an adjournment. Of course, he's very conscious about the entire bucket of cases that are there, and if he starts giving an adjournment, your case probably won't be the first and the last one. So that's flexibility is there. Overall flexibility in the process is there for sure, in the sense that I've already explained. So, you can have hearings at 7:30 in the morning, you can have hearings at 9:30 at night. Like Kriti and I have a short hearing this evening at probably 8:30 today. So, so that flexibility is there. And, literally put, there is, just think of it in this way. You're having a dispute resolution process where the arbitrator, both sides of advocates are on the same WhatsApp group. So it's, in a sense, it breaks that formality, right? It's just easier to communicate, and you're only doing it for ease of communication. But the moment you've talked about things like WhatsApp, there is automatically a breakdown of a barrier, which in a high court you can't do. You can't have the judge on a WhatsApp. I mean, it's not believable. It's not possible. So, I'm just talking from those kind of things that, make the flexible, process more flexible, informal. It gives an opportunity for the team to be, spread out, saying, okay, Ankush can't take this, somebody else will take it, third person can't take it, so on and so forth. That, and there is so much of advance notice in matters like this, that, one can adjust, arrange, so many times in court matters, you're probably sitting in one evening at 6 o'clock, and you'll find out that the notice board has come out for the next day and your matter is listed. What do you do? Can you tell the judge that you didn't inform me? You can't. So, in that case, there are many such things, but I'm more talking from a student's point of view and probably a potential junior's point of view, because you'll face these problems a lot more than we do. Of course, we do, but we're not the first port of call there. Let's put it that way. Kriti, you want to add something here? Feel free. Yeah?
Sure, Ankush, I shall.
Yes, Anya, go ahead.
All right. So the next question we have is from Himanshu. The question is, petroleum arbitration is one of the undiscovered field of arbitration in India. How can one pursue career in this field?
So it's a highly technical question, and I think I've just done one or two matters where we were advising for a state petroleum corporation against, it was a drilling contract. So the company had engaged these rig contractors. So you find these in the middle of the sea, these massive monster looking machines that are there, so they are those oil rigs, and basically they are those ships or whatever that are permanently stationed there for 6, 12, 18, 24 months. So we had they had commissioned one of those rig companies, probably one of the top 5 or top 6 in the world. And the issue that landed up before the arbitration was, at the end of the day, whether it was a well-based contract or a time-based contract. To give you an example, the contract initially was to drill wells under the seabed. So, and the contract was a little gray. Of course, that's how the claimants had talked about it, saying that, the minimum period was, so-and-so time. And then, if we overstayed, then we'll claim further rate from you. And we said, nothing doing. How can we have control over whether you take 1 day to drill a well or you take 100 days to drill a well is your problem. I am only the person giving you the instruction to drill. So, of course, that was a massive arbitration, and it was before the amendments came into place. And I'll tell you very quickly where I'm going with this. The arbitration took years to complete, so everyone landed up, making money, if I may say that, except for the claimant who lost everything. But, the point that, we want to say is that there is a lot of scope in this area. It's great. again, it's very specialized. So you need to understand a lot of technical terms. Like if I remember, okay, it'll come to me. I think it's called, there's something called an appraisal well. There is something called, there are different types of wells that you drill. There's something called a J-shaped well, and there's just this unbelievable terms that are there. I mean, we had to invent. I mean, literally, when we were talking in this language. It became so much of a part of us. So in that's on a lighter side, of course. I think the point is that there is a lot of scope there, and when this kind of an industry is continuing to blossom and continuing to go on, keeping aside the current times, it's going to be this kind of an arbitration on petroleum, as I said, energy, infrastructure, EPC is going to be prevalent worldwide. So it's a great this thing. I would only say that it's probably should not be restrictive, because I'm also aware that Petroleum and Gas Natural Board is also a board that is set up to decide these disputes, but that is not covered. I mean, arbitration doesn't look at those. That's more regulatory in nature. Arbitration is more of a contract between both the parties. So yeah, I mean, I'd say it's a great topic, but it's probably a bit too narrow to just focus your entire career on.
Thank you. So it was a very interesting response. We move on to the next question. It is by Prakhar. What's the scope of working as a tribunal secretary in India? What other avenues one can explore in area of arbitration while in law school to master the subject theoretically and practically?
Okay, as a little bit of a different one. I don't know the role of a secretary in tribunals. I probably know that in institutional arbitrations, you have, like CIAC or ICC or LCIA, they have representatives, who probably talk a lot about, go, jurisdiction to jurisdiction and explain, what the institution is all about and why it's beneficial over the other institution, etc., etc. That's of course from the admin point of view. I don't know if that's the question that you were asking. Can you repeat the second part of the question, ma'am? I've just missed it.
Yes, sir. So the second part of the question is, which other avenues one can explore in the area of arbitration while in law school to master the subject theoretically and practically?
So it's difficult, to say that, I think, it's good to read, continue to read up on this. But I think, honestly, the person correctly will be Kriti to answer this question. Kriti, any thoughts? Please go ahead.
Yes, sure. Primarily, I actually wanted to address the former part of the question as well.
Go ahead.
Tribunal secretaries, in the question that you asked was specifically to India. We, as such, I mean, tribunal secretary as a concept is centric to institutional arbitration, just like how Ankoosh was saying. I had the pleasure to actually attend a conference which was organized by LCIA, where the tribunal secretary's role was the main discussion point. In India, you wouldn't see much, to be very honest. Because in India, it's just so that ad hoc arbitrations are more prevalent. Arbitrations, we've seen matters where the matters have gone to CIAC, LCIA, etc. And tribunal secretaries are persons who belong to the institution itself, and they're actually somebody who work with the panel of the arbitrators. They do interact with clients on claimant and the respondent, if I may, but essentially they are for the arbitrators, even to an extent that they sometimes actually help arbitrators write awards if they're procedural, etc. So the role is actually something that you'll end up seeing in an international arbitration with an institution. The second part of what practical and theoretical things you could actually do when you're in law school. Ankoosh was rightly saying that the procedural laws are extremely important. Yes, in arbitration, you're not supposed to necessarily follow to the T the rules of CPC and the evidence law, but those are irrespective, no matter what, they are essential to any form of trial. Secondly, I think maybe from practical perspective, you would get a lot more practical incentives. Either you have college activities, or if not, then even internships, if you're able to do it for a longer term. Since I was in Pune, I didn't have more than 2 months of gap to do my internships, what often I used to see people do is to attend conferences, seminars, where you do interact with experts who are actually practicing at the moment. So that's where you get the practical information, because the book version of a trial may be very different from how a real trial works. I hope I've actually answered the question.
Thank you, ma'am. Thank you, sir.
But I'll probably just add one thing. I think Kriti's point is very fair. But, I think at this point of time, and I mean, the question is also to Kriti, is that, is it advisable, to restrict a particular learning? Because I understand that internships are few. I don't think everybody lands up getting internship. At least this is what my general knowledge tells me. And whether it's whether it's a good idea to be restrictive in saying that, okay, I'll do this and that, or is the idea that, in the 5-year program or the law school program that you have, is the thinking that, you should get exposure to as much as you can. I don't know, how generally students think. So it's probably good that if you guys both of y'all can probably have some thoughts.
Ankush, actually agree. There are one thing that's for sure there is that one is the practice of arbitration law itself, which is you are actually only and only restricted to how the act actually is interpreted, etc. The other one is actually practicing arbitration, which is a mode of dispute resolution, which is what Ankush and I do, which is what Ankush does more actually, which is that arbitration, instead of going to a court, you're going for an arbitration, which if that's the choice that everybody's making, they also need to know other technical laws. Like Ankush and I are doing one arbitration, which is actually about a software. It has nothing to do with, I mean, there is a part of it which is about section 17, 19 application, etc. But essentially, it's a commercial matter about a software. So just merely about the Arbitration Act wouldn't really help in going through the trial. But unless your choice is that you want to be a solely Arbitration Act specific lawyer, I mean, what I mean is you practice arbitration law in terms of interpretation, in terms of how the act works and all of that. So that they're actually two very separate things, which I also realized quite later in my college, but there is a distinction.
Indeed, ma'am, indeed. Thank you for the detailed response and covering all the aspects. Moving on to the next question. What, according to you, should be the necessary development that the field of commercial arbitration needs, looking at the current market structure and changes coming in the area of corporate laws? The question is asked by Anuj Sharma.
So again, I think it's the same thing. Arbitration has never been left behind, never wanted to be left behind. So it's I think done very well, and it'll continue to engage, in keeping up with the corporate world and the corporate times. Of course, it is restricted because it's a creature of contract. So any regulatory action, any government action, any law enforcement action, of course, not going to cover it. So anything related to SEBI or white collar or things about copyright infringement, which are more rights and rem and things like that, are always going to be beyond the purview of the arbitration handler. So in that sense, I don't see it's behind in any form. Of course, a lot of forums are developing arbitration rules and how do you sort of work a little more smartly, more flexibly, etc., etc. But I think at the end of the day, in whichever platform of arbitration work you're doing as a lawyer, those basics that I've simply tried to explain usually would not change.
Thank you, sir. So I think we'll be taking up 2 to 3 more questions and then we'll be wrapping up. Now, the next question is the provision for challenging the impartiality of the arbitrator misused many a times by the parties? It's asked by Apratim.
Kriti, go ahead.
Sorry, I couldn't hear.
The question is the provision for, sorry.
I'll repeat. Is the provision for challenging the impartiality of the arbitrator misused many a times by the parties?
Okay. I have not seen any case where people have actually misused it. The threshold is not that low to actually you could always challenge it, but you have to go before the arbitrator itself because you have competence principle there. But it's very rare that the parties do often end up challenging it. And I think a part of it, unless Ankush disagrees, part of it is because the arbitrator itself is actually going to be part of your legal fraternity and the community. And if your arbitrators are often going to be retired judges or very senior legal experts, it's in India at least, it's not that common for people to raise questions on impartiality of an arbitrator. We have come across a case where it was a foreign arbitration seated in London, where the arbitrator and one of the advocates of the claimant actually belonged to the same chambers. But in London, the concept of chambers is slightly different. It's not as we have it. There's a council chamber and there are juniors in the council chamber. But for them, it's more like like a lot of arbitrators and a lot of lawyers sort of come together. I wouldn't call it a club, but it's more of an association, if I may. And doesn't necessarily have to, you may not know everybody in the association if you're a group of people. So in India, it's not that common, I believe, because you pretty much know the legal fraternity and you're also appointing very, very senior experts. That's a general.
No, I completely agree. In fact, the reason I reached out to her was because we were doing a matter that had this interplay. So that was the point.
All right, so the last question would be, what, according to you, should be an ideal approach or path that students should follow in order to pursue a successful career in the field of commercial arbitration?
I have said that in the first 25 minutes, but I think, as I said, I'll...
so there's a second part to this question.
Go ahead.
Yeah. How important do you think a master's in commercial arbitration is for a student that is interested in building a career in international commercial arbitration? If it is necessary, do you suggest the student gains work experience before applying for masters?
Okay, look, I don't have any idea about this. I can ask Kriti, but I know for a fact, no, she doesn't have much of an idea at this moment. But I think, I'll talk about myself. So when we grew up from law school and it was a government law college, of course, to be very honest, it had a restricted, 15 years ago, it was, not as developed as many of the national law schools were. So you'd find many lawyers from Bombay, who would give the solicitor's examination. And, I did, sign up for it, and I successfully cleared my solicitor's examination because, one needed to have a more stronger foundation of education under the belt. And solicitor's examination, is just for people who are not familiar, it's set as a practical paper and is set by practicing solicitors who set your paper and correct your paper. So I found that very helpful. And the distinction I make from a foreign practice to here is I don't know how much it will help, because at the end of the day, you're practicing Indian law related issues. I definitely see one upside that, it's a great exposure. But again, you should be very clear about why you're going there and what you want to do, rather than, I'll do a XYZ LLM and come back and I'll be like received with, great pomp and show. I don't think that's going to happen. I think that's changed. If you're doing it for yourself, and you probably, it just helps in, landing up, an edge over somebody else to get a job. I'm sure it's well recognized. But if it is to do with day-to-day practice, if you look at X counsel or Y counsel and Y lawyer and X lawyer, you can't tell the difference whether he or she has done a foreign element or not.
Thank you, sir. That would be all with respect to the questions. Thank you for the great responses. I hope the students present here will have great understanding of the subject. Thank you so much, sir. Thank you so much, ma'am. That would be the end of Q&A. Thank you.
It's my pleasure.
Thank you so much, sir, and Kriti for introducing the concept of commercial arbitration so well, and all the queries which were being laid down by the attendees. And thank you so much, Sanya, for hosting the questionnaire round. Now I would request Ishna, our another student of New Law College, Bharati Vidyapeeth, deemed to be university, and a student member of Madhyasthta, our ADR Cell, to render the vote of thanks. Ishna, please.
Thank you, ma'am. Respected sir, I, on behalf of Bharati Vidyapeeth deemed university and Madhyasthata, the ADR cell of New Law College, extend a hearty vote of thanks for gracing today's session and for being a part of our new initiative. A big thank you to you, sir, for sharing with us your knowledge, experience, and expertise in the field of commercial arbitration and providing your valuable insights regarding the career prospects in the field. I'm sure students present here have taken a note of the same and will be greatly benefited from it. Further, I would like to take the opportunity to place on record a special thanks to our principal in charge, Dr. Bhagyashree Deshpande Madam, and our faculty coordinator, Mrs. Shivangi Sinha Madam, for providing their constant support and guidance at each and every point. And a sincere thanks to the management team, Bharati Vidyapeeth Deemed University, New Law College, for their support throughout. Lastly, I would like to extend our heartfelt thanks to all the students participating today. And with this, we come to the end of today's session. We hope to see you all in our next session, for which the details will be circulated shortly. Thank you once again for gracing the event with your presence. Thank you very much, all of you.
Thank you. Thank you.
Thank you all for joining, and I really hope that we all are benefited from our first session of our Prudentia Amicus series. We hope to see you all soon in our next session of Prudentia Amicus with our next amicus, who will be Ms. Neeti Sachdeva, who is the Secretary of MCIA. And the discussions of the session will be on international arbitration, and the details of which will be circulated shortly, which is on 24th of October 2020. And I once again would like to thank each and every one out here, all the technical teams, the members, our principal in charge, Dr. Bhagyashree Deshpande ma'am, to be there as a constant support, Ankoosh sir, for such an insightful session, and yes, of course, Kriti, because of your idea, we are having this webinar today, so thank you so much.
Thank you.
Thank you.
Thank you.